Okay, so I think we can move on to the main event now, and hopefully we've got most of you with us. So we all know that the people agenda has been dominated over the past year by managing the fallout of COVID-19 and the ramifications of Brexit. And we're still very much in the thick of those two issues, which can mean it's a real challenge to stay on top of other changes. And in the HR sphere, there are always changes afoot, and 2021 is no exception. So the purpose of today's session is to survey the reforms that we think you need to know about. And we hope that this will give you a pathway for navigating the compliance challenges for the year ahead. And as we go through the session today, Tom and I will suggest a number of action points for you. By all means, jot them down, but we will circulate after the webinar a copy of the slides, the recording of the webinar, and also our BDBF 2021 HR roadmap, which will capture all of the action points that we will talk about today. And we also give them a red, amber, green rating. So do feel free, if you prefer, just to sit back and listen today. Okay, so on to our first topic, the recruitment of EEA and Swiss nationals post-Brexit. And just for ease, I'm going to refer to this cohort of people as EU nationals. So as an employer, you need to make sure that your workers have the legal right to work in the UK. If you don't, you can face civil penalties of up to £20,000 per worker. Now, nationals of EU member states, so that's the EU 27, and then the EEA member states, Norway, Iceland and Liechtenstein, plus also Switzerland, have the reciprocal right to live and work in other member states as part of their free movement rights. Now, from your perspective as employers, free movement meant that engaging EU nationals was easy. All you had to do was establish their nationality. But Brexit has changed all of that. The transition period ended on the 31st of December. And so from the 1st of January 2021, EU nationals lost their automatic right to live and work in the UK, and of course, vice versa. However, Irish nationals are not affected by these changes. They retain the right to live and work in the UK under something called the Common Travel Area, which I'm not going to talk about any further today. But how this change works in practice depends on when the EU worker came to live here. So those that were here before the 1st of January have various options available to them to secure their right to stay and work in the UK. So if eligible, they could apply for British citizenship, which provides a permanent right to work in the UK. Alternatively, they could apply under the EU settlement scheme. And if they've been in the UK for 5 years plus, they are entitled to apply for settled status, which also confers a permanent right to work in the UK. If they've been in the UK for fewer than 5 years, then they're entitled to apply for pre-settled status. And this confers the right to work in the UK for 5 years from the date of grant. And then once they've achieved their 5-year anniversary of living in the UK, they can then upgrade to settled status. So in other words, pre-settled status is a bridging status to permanent residence. Alternatively, you may have some EU national workers who haven't applied for any of those statuses yet, and that's okay for now. They continue to have the right to live and work in the UK at the moment, but they must apply for either settled or pre-settled status by no later than the 30th of June 2021. It's in their interests and in your interests that they do this, because if they don't, they will be subject to the new immigration rules. And of course, they may not qualify to work here under that new regime. But even if they do qualify, the process is expensive and it takes time, potentially up to 4 months, meaning that there could be a period of time between the 1st of July 2021 and the acquiring of a visa under the new system where they don't have the legal right to work in the UK. And that would mean that you're potentially into dismissal territory. So the key action point here is to encourage and support any workers who haven't already applied to do so, applied for the settled status or pre-settled status to do so as soon as possible. Now, for your EU nationals coming to work in the UK after the 1st of January, they are in a different bracket. So they will need to qualify to live and work here under the UK's new immigration system. And at the very heart of this system is the points-based immigration system. And the intention is that this system will treat all migrant workers the same, regardless of where they come from. Now, under the PBS, anyone coming to work in the UK must meet a specific set of skills and salary criteria for which they score points, and visas are awarded to those scoring 70 points or more. And typically, your EU national worker will need what's called a skilled worker visa. Just as an aside, there are other routes available, such as the global talent route, the graduate route, the intra-company transfer route, or they might qualify via their spouse or their ancestry. I'm not going to talk about those other routes today, but do just remember that if you have a candidate who doesn't qualify via the skilled worker route, then it's worth exploring those alternatives. So how does the skilled worker visa route work? Well, there are a number of stages. First of all, you will need to apply for a sponsor license in order to sponsor the prospective candidate. You may already have one, but if you don't, you'll need to apply for one online. Those applications can take up to 8 weeks and they carry a fee, which differs depending on the size of your organisation, but it can be up to about £1,500. And individuals within your business will need to take on responsibility for ongoing compliance with those sponsor licence obligations. And some of those will fall upon HR in all likelihood. Once you've got your sponsor licence, then you can issue your candidate with a certificate of sponsorship. And then the candidate takes that away and makes a visa application. And they have to meet those skills and salary threshold that I mentioned earlier. I'm not going to go through what those are right now, but if they achieve the 70 points, then they will be granted the visa. And that visa application will usually take between 4 to 8 weeks. Once the visa is granted, then they can work for you and you will be subject to various ongoing duties, such as compliance with the immigration rules, reporting duties and record keeping. And you will also need to pay the immigration skills charge of £1,000 per worker in year 1 and an additional £500 for every 6 months thereafter. So the key action point for you here is that if you don't already have a sponsor licence and you want to have the ability to recruit new to the UK EU nationals in future, then now is the time to think about it, rather than waiting to the point of hire, because that will likely delay the recruitment process. Once you've got it, the sponsor licence lasts for 4 years, so then that problem is off your desk. And just remember that if you do go down this route, you will need to make sure that people within the business are allocated responsibility for ongoing compliance and that those people have the appropriate training. I'm just going to give you a quick plug here for some materials produced by the CIPD. Some of you may have already seen these. They've produced this quite helpful flowchart. It's pretty basic, but quite helpful just to organise your thoughts around the new regime. And they've also produced a detailed guide for employers on the new immigration system. And I'm happy to circulate links to those after the webinar, but I did find those quite helpful when I was thinking about this area. Okay, so on to our second development, and this is a change affecting the engagement of certain types of contractors. So the way in which the off-payroll working rules, also known as IR35, the way in which they operate within the private sector is going to change on the 6th of April 2021. Now, you may remember that these reforms were due to come in last year on the 6th of April, but they were deferred as part of the government's response to the pandemic. As far as we know, these changes are coming into force this year. There have been no indications of any further deferrals, and indeed steps have been taken to get ready for the rollout, such as updating guidance and producing secondary legislation. That said, the deferral only came 3 weeks before the intended rollout date last year, and so I don't think we can completely rule out the possibility that it might be parked once again. But for now, I think we have to assume it is coming in and we have to work towards compliance. So I'm going to give you a quick refresher of what it's all about and some preparatory steps that you might want to think about. But really, this is quite a complex area. And so as part of the follow-up, we will circulate a note that we have prepared, which will take you through everything in a bit more detail. So in a nutshell, what is this all about? I'm going to come on to some diagrams in a moment, but I'll just give you a bit of an intro. So the IR35 rules were designed to crack down on the problem of disguised employment. And disguised employment is where a worker supplies their services to an end user client, and that would be you in this scenario, via an intermediary. And that's usually a personal services company controlled by the worker. And in a disguised employment situation, they are doing this in order to benefit from the preferential tax treatment afforded to contractors. But in reality, this is disguising the fact that they are employees for tax purposes. And the consequence of that is that the government loses out on quite a bit of tax revenue. So the IR35 rules were brought in to tackle that problem. And what they did was to require the intermediary to determine whether the worker should really be regarded as an employee for tax purposes. And that determination process is called the status determination. And if they did determine that the worker was an employee for tax purposes, then they had to tax them as an employee. But the obvious problem with this approach was that responsibility for making the determination rested with the intermediary, in other words, the worker who had the vested interest in not being an employee for tax purposes. So in 2017, the government rolled out 2 key changes to the IR35 rules within the public sector, which removed the intermediary's role in the process. And it is these 2 key changes that are now being extended to medium and large employers in the private sector. And our note explains which employers are caught by the new rules and which ones are out of scope. So what are the changes? Well, the first change is that status determination that I talked about moves away from the intermediary and up to the end user client. And that process is notoriously difficult. And unfortunately, you're not permitted to just make a blanket determination for all the contractors that you have. You have to do it on a case-by-case basis. Secondly, if the worker is found to be an employee for tax purposes, then the person who pays the fees to the intermediary must deduct income tax and employee NICs and also pay employer NICs. Now that person may be the same as the end user client, but not always. So let's look at a couple of examples to bring this to life. So in a simple 3-party chain where you have the worker who has an employment contract with the personal service company, who has a contract for services with the end user client, this is what happens. So the end user client needs to make that status determination that I talked about. And they need to, SDS refers to status determination statement. That's what that means. They need to pass that information down the chain together with the reasons for their determination. They need to pass it to the PSC and also down to the worker. In addition, they need to set up a dispute resolution process to allow the other parties to challenge their decision if they disagree with it. And also in this example, what you can see is that the end user client is also the fee payer. So if they were to determine that the worker was an employee for tax purposes, then they would also be stuck with the fee payer's obligation to apply payroll and absorb the cost of employers' NICs at 13.8%. Now, in a slightly more complex chain, different parties have different roles. So, for example, in a four-party chain, where we have a worker, intermediary, the PSC, an agency, and a client, the roles are a little bit different. So the end user client would still have to make that status determination, and they'd still need to pass it down the chain, but not to everyone. So they would have to pass it to the party next to them, which in this case is the agency, and they'd have to pass it to the worker. They don't have to pass it to other parties in the chain. Instead, each party cascades it down the chain. The end user client would still have to operate that dispute resolution process, however. But in this scenario, what you can see is that they are not the fee payer. Instead, it's the agency that pays the fees to the PSC. And so if the end user client determines that the worker is an employee for tax purposes, it's the agency that then will need to apply payroll. So I think what you can see is that this system is really quite burdensome for organisations engaging contractors via intermediaries. Now, this is quite a busy slide. I'm not going to talk through it. It's really just some action points for you. Now, you might want to think about whether you could avoid the regime altogether or at least limit its application. And I've set out some thoughts on how you could do that on this slide, and all of them are covered in depth in the note that will circulate, so I won't talk through them now. But if you can't avoid the regime, and some employers in certain sectors will not be able to, then there are some fairly pressing action points for you, and they're set out in the third column. So you'll need to be auditing your contractor arrangements and having a dialogue with your contractors about what's going to happen. You'll need to consider who in your business is going to have ownership of the process and how they're going to make those status determinations. You'll need to devise that dispute resolution process and again have someone owning it. And you'll need to review and amend contracts to make sure that they work within the new regime. And you may also need to review your payroll software. Okay, so that's all I'm going to say about IR35. I'm going to hand it.
Thanks very much. So once you've jumped through those hurdles in relation to recruiting people, you'll need to issue contracts of employment. And in this area, there are 2 points which may affect the drafting of employment contracts which are under consultation, and a third where we're awaiting legislation. So firstly, non-compete restrictions. On the 4th of December last year, the government launched a consultation on proposals to limit or potentially even ban the use of post-termination non-compete clauses in employment contracts. Now, importantly, they're only looking at those restrictions which prevent an employee from working for or setting up a competitor, and not those which target the solicitation of clients, for example, or the protection of confidential information. Now, it's not the first time that the government's looked at shaking up this area in recent years. There was a call for evidence in 2016, and at that time, ministers were influenced by a report published by the US Department of the Treasury, which analysed the economic effects of non-compete clauses and made a case for their reform. Now, unsurprisingly, at that time, the responses were fairly polarised, with established businesses favouring the current law and new ones looking for much more flexibility. The proposals were shelved at that time, but they're back on the table just a few years later. The press reports say it's because ministers are keen to make the UK more attractive to EU entrepreneurs post-Brexit. The official line in the consultation paper is that the government is exploring avenues to boost innovation through the diffusion of ideas, create the conditions for new jobs, and increase competition as part of our recovery from the COVID-19 pandemic. The consultation is looking at 2 proposals, essentially. In option 1, they're looking at mandatory compensation. So non-competes would only be enforceable where the employer pays for the period of the restriction. And this mirrors the approach taken in a number of European countries such as Germany, France, and Italy. And the logic is it forces employers to really think about whether they want to non-compete and creates a financial disincentive to use it. And the consultation asks for views about the right level of compensation, suggesting 60, 80 or 100% of normal earnings, or seeking views on whether it should be some other amount. And the government is also seeking views on supplementing this requirement by obliging the employer to disclose the terms of the non-compete at the outset of the relationship, which I find a bit bizarre because you'd have to do that anyway in order for it to be enforced, but perhaps what they're talking about is greater transparency around its meaning, or restricting the maximum length of non-competes. And at the moment, the current law says that they must go no further than is necessary to protect the employer's legitimate interest. And in practice, you're unlikely to see them exceeding 12 months, and they more usually sit around the 6-month mark. Option 2, the consultation is looking at a complete ban on non-competes and stresses the positive effect this could have on innovation and competition, and makes reference to California, where such restrictions are unenforceable, and that's obviously the home to many of the world's most innovative organisations. The consultations overlooked the fact that many of the big tech companies in California were the subject of a multi-million-dollar antitrust case when they were accused of running a non-poaching system in relation to each other's employees, and therefore getting non-compete protection by the back door. So if option 1 is taken forward as a matter of some urgency, you'll need to benchmark your existing contracts where you have these clauses against the new time limit. It may be worth undertaking some sort of audit now. If you're within the new time limit, then fine. If not, you'll need to consider whether you're willing to compensate the employee for that period, and if not, look at renegotiating the clause with the employee. And you'll probably have to provide something of value to the employee at that time in return for entering into fresh restrictions. And you'll obviously need to audit template contracts of employment as well. If option 2 is taken forward and non-competes are banned completely, then you'll need to remove the offending clauses and also look at beefing up other post-termination restrictions to see that you're adequately covered. So it's potentially a very significant change. It could have a major impact on sectors that rely on these clauses, such as insurance and technology. Keep a close eye on the consultation. It closes on the 26th of February. We'll be doing a response, and so if you'd like to contribute some thoughts to that, then please do let me know. The second item under consultation is a potential extension on the ban on exclusivity clauses. They're currently banned for 0 hours workers, and the government's looking at extending those to low paid employees, so those earning less than £120 per week. And again, that consultation closes on the 26th of February. The final change affecting employment contracts is the use of non-disclosure agreements, confidentiality arrangements. And the government consultation has been completed and legislation has been promised as soon as parliamentary time allows. And so we expect that to be this year. And if you're responsible for HR in a law firm or you're a lawyer yourself, you'll already be familiar with the much more onerous rules around the use of NDAs in the Solicitors Regulation Authority warning notice on this issue, which was expanded quite significantly in November last year. I'm not going to go into the details of what's expected with all of that, because we're going to cover that when we come on to talk on about settlement agreements, where those provisions are much more key. So the next area to be aware of, as well as rewriting employment contracts, is you may need to do the same with handbooks in relation to family-friendly policies. And a number of changes are afoot here and at different stages of development. So first and foremost, the protection available for pregnant workers and new mothers in redundancy situations is likely to be strengthened this year. As you know, the current position is that women on maternity leave have priority for suitable alternative vacancies in redundancy, but that protection doesn't apply to pregnant workers, and it doesn't apply when the woman's returned to work. That's set to change, and the government has plans for a new employment bill which will extend the protection in that way and apply from the point the employee notifies their employer of their pregnancy to the point 6 months after the return for work. And in its response to the consultation, the government actually went further and said that the protection will also apply to those returning from adoption leave and shared parental leave, although the period of protection will obviously be different in the cases of those kinds of leave. And again, it's another consultation where we're told that legislation will be introduced when parliamentary time allows. In this area, it's also worth being aware of the Pregnancy and Maternity Redundancy Protection Bill, which is a private members' bill started by Maria Miller MP on its way through Parliament. And if that's passed, it will completely prohibit redundancy during pregnancy and maternity leave and for the 6 months after return, save where the employer is effectively closing down, the whole of its business or business in a particular area. Private members' bills don't typically end up on the statute books, but given the negative impact of the pandemic on the employment of women with childcare responsibilities, it's one proposal which could gain cross-party support and is worth keeping an eye on. And either change will necessitate a change in your policies and also training for managers whose job it is to implement them. The government's also looking at plans to upgrade family leave rights in these 4 areas. The first relates to a consultation which sought views on a major shake-up of family-related leave. It closed in November 19, and over a year later, no response has been published. It's not clear whether it's just fallen away because of Brexit, fallen by the wayside, or whether it's been quietly shelved. I'm not going to go through the detail because of that. But broadly, it sought views on enhancing leave and pay rights as they stand, or actually just a much more radical scrapping of the entire system and replacing it with a single model of family leave with periods of non-transferable leave and transferable leave between parents. The next area is in relation to neonatal leave and pay. The government's response to this consultation was published in March 2020. They've confirmed they will legislate in this area. It'll be a right to take up to 12 weeks paid leave for parents whose children require neonatal care in relation to a period where they're 28 days old or less, and they're admitted to hospital for 7 days or more. The leave will be a day 1 employment right, but entitlement to pay will depend on length of service. No legislation's been published, but the costings were set out in the spring 2020 budget, and that suggested it will not be enforced until 2023. So it's definitely coming. It's worth thinking about your approach at this stage. The next area is a proposed new right for leave for workers with caring responsibilities, a consultation which closed in June 2020, sought views in relation to a new form of 1 week's unpaid leave in order to provide care. It was referred to in the last Queen's speech and also dealt with in the spring 2020 budget. So it's something which is potentially coming down the train. And again, worth thinking about now, what will you do in relation to that sort of right? Will you offer any enhancement? Will you offer pay? And finally, the government has also consulted on introducing a requirement on large employers, so those with more than 250 employees, to publish their family-related leave and pay policies. The consultation closed in October 2019. A response has yet to be published, but we think, ultimately it will be something which will come in. It's in keeping with the government's transparency agenda in recent years, for example, in relation to equal pay reporting, and it doesn't cost the government anything. And it will be quite a significant change, actually, for employees who are changing jobs and who don't want to be asking about those sorts of policies as part of the interview process. So it's worth thinking about your policies and whether they would ultimately be fit for publication. And I'll hand you back now to Amanda.
Thanks, Tom. Okay, so the next thing we're going to look at is the final phase of the furlough scheme and some things you might need to think about when managing its closure. So the current phase of the scheme started running on the 1st of November 2020, and it's due to close on the 30th of April when the whole scheme comes to an end. So the way that the scheme works now is the way that it's going to work until it closes, subject of course to any further extensions or changes that may be announced. And in the last few days, there have been rumours of yet further extensions, so watch the March budget for that. If there is an extension, then the timeline that I'm going to show you in a moment will be pushed back accordingly. So for those of you that have dealt with furlough, you will know that keeping up with the detail of the scheme is extremely difficult. There is a lot of detail and it changes regularly. For example, some of the guidance notes are now on their 40th version, that's 40th version. So it's pretty tricky to stay on top of. BDBF has produced a guide to the scheme, which will bring you up to speed on all aspects of the scheme, and I'm happy to circulate that after the webinar if that will be helpful to anyone. But for our purposes today, I'm not going to go through that detail, you'll be pleased to hear. I'm just going to remind you of some of the key features of this final phase. So the scheme has been reopened to new entrants. It had previously been closed. So if you haven't furloughed to date, that option is still open to you. Employees may be fully furloughed or flexibly furloughed, which means they can work part-time and be furloughed part-time, but it remains the case that an employee cannot perform any work at all during any furloughed hours. If they do, it will invalidate your claim. Employees will still receive 80% of their usual pay for their unworked hours, up to a maximum of £2,500 a month. You no longer, as the employer, have to contribute towards the wages of furloughed employees for those unworked hours. Of course, if they're working on a flexible furlough arrangement and they're working part-time, then you would be responsible for paying them for hours worked. Although you don't have to contribute to the wages for furloughed hours, you do have to pay employers' national insurance and pension contributions in full for those hours. And then the final feature that I think is worth pointing out is that HMRC are going to publish the names of employers who have made claims, and this was not present in previous phases of the scheme. It's not quite clear what the purpose of this list is. It does feel to me a little bit like a name and shame exercise designed to deter employers, or at least large high profile employers perhaps, from claiming under the scheme. There is an exception which says that if you can demonstrate that publication would place staff or their relatives at risk of violence or intimidation, then you may be able to avoid being named. And the fact that that caveat has had to be put in speaks volumes, I think. Okay, so that's the key features of the scheme. And we can see that it's coming to an end. So I just wanted to mention a few points around managing the closure of the scheme. So if you're going to bring furloughed employees back to work, then there are a number of issues to consider, such as whether they can return to their previous work pattern or whether you'll need to negotiate a reduction in hours, whether on a permanent or temporary basis. If they're returning to work in your premises, is the workplace COVID secure? And you may also want to think about issues such as imposing COVID testing or asking workers to have the vaccine before they return. And these are complex issues, and unfortunately we don't have time to cover them today, but we are planning further webinars to address these types of issues, so we'll keep you posted about that. But what's likely for many businesses at the end of the furlough scheme is the need to make redundancies. And here there are a number of pitfalls to avoid. So first of all, you need to be careful to get your redundancy pools right. Only pooling furloughed staff could well lead to accusations of procedural unfairness and potentially also discrimination, given that women and disabled staff are more likely statistically to have been furloughed. You also need to be careful with the criteria that you apply to select people for redundancy. And here, I mean, you need to be careful not to unfairly disadvantage your furloughed staff. So, for example, if you're using performance criteria, you may need to go back further for furloughed staff than you would otherwise have done. And importantly, you need to get your consultation process right. If you are making 20 plus redundant in a 90-day period, then you'll be into the collective consultation regime, requiring either 30 or 45 days consultation before dismissals take effect. And you can see on the timeline that I've set out the last possible dates for those consultation periods to start if you wish to terminate on the last day of the scheme. And depending on your arrangements, you may also need to undertake an election process to elect representatives for the purposes of that consultation. Of course, as I said before, if we do get an extension to the scheme, these dates would be pushed back. So you'll need to plan your process pretty carefully, bearing in mind, of course, that a failure to file the HR1 properly is a criminal offence, and a failure to consult carries with it the risk of protective award claims of up to 90 days gross pay per employee. And just the final point on that slide is that your payroll team dealing with furlough claims will need just to make sure that they get their final claims in within time. So if the scheme does close on the 30th of April, the last date for submitting a claim would be the 14th of May. Okay, an issue sort of aligned to what I've just been talking about is flexible working. And we think an issue for employers is going to be how you deal with a surge in flexible working requests. And I'm also going to alert you to some future changes in this field. So the rollout of the vaccine signals the hope of return to normal life, including in the world of work. But after a year or more of working from home, will staff be prepared to return to commuting 5 days a week? Well, the boss of Unilever doesn't think so. Alan Jope said that he didn't anticipate workers returning to the office 5 days a week, and he said that he thought this was a very old-fashioned notion now. And financial services and tech businesses such as HSBC, Lloyds, Twitter have all introduced home working already on a permanent basis to a greater or lesser degree. Now, you may decide to lead the way and adopt the Unilever style approach and embrace new working patterns. But I think that even if you don't, this is likely to be something that you're going to have to grapple with in any event, both in relation to your existing workforce and new recruits. So thinking about your existing staff first, a survey of staff from over 500 financial services institutions in the city found that 70% felt that home working was a positive experience. And another survey of working parents found that 55% of them wanted a hybrid form of working with no more than 3 days in the office per week. So I think it's realistic to expect an influx of flexible working requests once things begin to return to normal. And you'd really be wise to consider now whether you are willing to agree to continued home working, and if so, to what extent. And if you are not willing, then it's worth thinking about the grounds that you might rely on to refuse such requests. And further, if you feel you can accommodate some but not all requests, then you might want to think about how you'll go about choosing who is granted the right and who isn't. Now, when it comes to turning down requests, if you can show that the quality of your product or your service has deteriorated, or the employee's performance has dipped as a result of home working, then you should be on fairly good grounds to reject a request. But rejecting requests will be harder where the employee can demonstrate that they have worked from home effectively for quite a long period of time. So you might want to start collating information about the impact of home working on your business, as this will inform how you respond to requests. remember that if an employee can show that you have failed to deal with their request reasonably, or that your decision is flawed, they are entitled to bring a tribunal claim asking for the request to be reconsidered, and also seeking up to 8 weeks compensation. And of course, other more valuable claims may also be available depending on the circumstances. And really, that's just a headache you don't need. So the key action point is to start thinking about what you can live with, I think, really. Generally, if you can meet employees halfway, you'll probably avoid a dispute. Now, as far as your new recruits are concerned, just be aware of possible changes in the law here. The government is planning changes to legislation, and it is signalling that it will put its weight behind flexible working for all jobs. So there are plans to make flexible working the default position for all job roles, unless the employer has a good reason why it should not be offered. So this will represent a shift in the burden from the employee having to persuade you to allow flexible working for a role, to you having to persuade the employee why it can't be allowed. The government has committed to consult on this before it's introduced. That consultation hasn't been published. Once it's out, you may wish to submit a response to make sure that your views are represented. And also, as Tom mentioned earlier, when he talked about family-friendly reforms, the government consulted on requiring employers to publish their family-friendly policies. That also extends to flexible working policies. And again, we're just waiting for the government's position on that. But I would say here that your action point is to spend some time making sure that your policies are fit for purpose as things currently stand, but also be ready to adjust them if flexible working becomes the starting position rather than something that the employee has to negotiate with you. And you may also wish to devise a standalone home working policy if you don't already have one. I'm going to hand back to Tom now to talk about pay inequality.
Thanks. So pay inequality is definitely well back on the agenda for 2021. HR and payroll teams at large employers had a reprieve from crunching gender pay gap numbers in 2020 because the government paused the publication requirement in light of the COVID-19 pandemic. As far as we know, the deadline for private sector employers is now the 4th of April 2021. And the existence of the furlough scheme does complicate reports this year because the regime requires that employers omit from the calculations any employees who are on reduced rates of pay as at the snapshot date. So on the face of it, this means that employees who are furloughed on 80% of pay should be excluded from the calculation, whereas if you've topped up to full pay, then this should be included. And where a business has furloughed large numbers of staff and perhaps even whole functions where there's a gender bias, such as personal assistants, then the result is that the figures will be unrepresentative and out of keeping with previous years. So it's worth thinking if you're affected in that way and what your explanation will be in your accompanying narrative. And it may be that actually you produce quite a good result this year, but then it's going to drop back down next year, and that's what you're needing to explain. So businesses outside the regime obviously escape that headache for now, but employers should note there are plans to extend reporting to smaller employers. The Equal Pay Information and Claims Bill, or EPIC bill, is on its passage through Parliament. Again, it's a private member's bill, but one that does have cross-party support. And even if it doesn't end up on the statute books, it does definitely have the capacity to influence government policy in this area. It'll do 3 things, which I'll just go through now. Firstly, it would increase the gender pay gap reporting obligations to employers with 100 employees or more, rather than 250, the current threshold. Now, that'll bring us closer to other European countries, such as France, Belgium, and Spain, where the threshold is 50. And it will also require employers to publish an action plan for reducing their pay gap. So just reporting figures would not be sufficient. Secondly, the bill looks to bring in ethnicity pay gap reporting for employers at the same threshold. Now, this has been on the cards for a while, and Theresa May's government did a consultation in October 2018 on introducing it, and the government hasn't responded to that since it closed in January 2019, which suggests that as far as the government's concerned, it's been kicked into the long grass. But it does seem that it has public support, and there are a certain number of surveys and petitions which have demonstrated that, including the BBC reporting that it had obtained details of the responses to the consultation I mentioned, which revealed that 73% of respondents supported that reporting for larger businesses. And so that is definitely going to be something which will require a new layer of work for employers, because unlike gender pay gap reporting, you probably don't have the data at the moment from which you could undertake that reporting yourself. And finally, the EPIC bill seeks to change some reforms around equal pay law. And chief among these is a right for employees to know what their colleagues are paid. And if that comes in, that will bring about, I think, a very significant increase in equal pay claims, because knowledge of what the comparator colleague is paid is a big stumbling block for people trying to bring those claims at the moment. And a lot of the claims you see arise either because the employer is obliged to publish pay, such as in the case of Samira Ahmed at the BBC comparing herself to Jeremy Vine, whose salary had to be published, or where the employee finds out their comparator's pay by accident. So that will be potentially a very significant development if it comes in. Moving on now to talk about holiday pay. And I can't believe really the cases on this are still rumbling on. On the whole, they concern what elements of pay should be included in holiday pay for workers with normal working hours. So, for example, commission and bonuses and that sort of thing. Now, our regulations only require that basic pay is included and potentially leaves those employees shortchanged. The very brief history of the case law around this is that in 2012, the European courts told us that holiday pay should equal a worker's normal remuneration, which meant that pay which is closely linked to the performance of their duties and the tasks under the employment contract should be included. In 2015, the Employment Appeal Tribunal told us that normal pay extends to overtime, which the worker has to perform if offered, but which is not guaranteed. But at that same time, the EAT also stymied back pay claims by saying that underpayments had to be closely linked in time and could not have a gap of more than 3 months between them. And in 2017, the EAT told us that purely voluntary overtime could also count as part of normal pay, and that was repeated by the Court of Appeal in 2019. So all forms of overtime could be included, but back pay claims are quite limited by that 3-month rule. And that's how things stood for a while, until the Northern Irish Court of Appeal told us that that 3-month rule was wrong, and claims for deductions from holiday pay could be made even if there were longer gaps. And in June this year, the Supreme Court is going to hear appeals in 2 holiday pay cases, which will consider the inclusion of voluntary overtime payments and whether that 3-month rule is right. And that's important because, you know, that'll be the last word on these issues now. There'll be no further reference to the European courts. So if you've been holding the line on including voluntary overtime and the Supreme Court rules that it must be included, then obviously you'll need to adopt practices. And similarly, if it rules against that 3-month rule, the door to more valuable back pay claims will be opened again. And we're expecting that decision to be out sometime in the autumn. And it, of course, all depends on the government not deciding to remove those variable pay components from holiday pay altogether. There's been some rumours of plans to do that now we've left the EU. And in fact, as part of their opposition day debate starting today in Parliament at 2:30, Labour has tabled an opposition day motion opposing that move, among others. And there's a further Supreme Court case, which is coming on in November this year, which is also looking at how holiday for term time and seasonal workers should be handled. And finally, when it comes to holiday leave requests, don't forget that special rules were introduced last year to allow the rollover of some holiday where it couldn't be taken due to the COVID-19 pandemic, potentially over for the next 2 years. And so you may have higher rollover than you have been used to dealing with. Moving on now just to look at some changes coming in relation to whistleblowing laws. Try and move quite quickly through these as we're a little bit behind in relation to time. At the EU level, a new directive introduces protection for those reporting certain breaches of EU law, and EU member states have until December this year to comply and implement that. It's not yet clear whether the UK will introduce compliant legislation. Under the Brexit deal, the UK and the EU have agreed to continue to strive to increase labour protection, but ultimately we're free to do as we wish. But if we do depart from the EU's position, and the EU has evidence that that has a material impact on trade or investment, then they can apply sanctions, so-called rebalancing measures under the trade deal, such as tariffs. So there's some incentive for us to align, and given that there will be areas where the government will wish to diverge, it may be the case of picking battles, and this won't be one of them, and we would expect some form of decision from the government on this fairly soon, as there's not much time to get the legislation in place. In any event, if you're operating in other EU member states, you definitely will be affected by this, and will have to take steps to conform. The directive introduces measures to protect those reporting breaches of EU law only. It extends protection to the categories of people involved, to contractors, shareholders, job applicants, former employees, and it will require employers with 50 or more employees to have certain certain internal procedures for dealing with whistleblowing. So there'll be a certain amount of policy updating, compliance work and training needed if this change is brought in. And also there are 2 private members' bills currently on their passage through Parliament in this area. Again, unlikely to end up on the statute books, but I mention them here because they show that there is an appetite for changes in this area, despite the UK having quite a sophisticated system of whistleblowing protection compared to other jurisdictions. So the first bill looks at protecting whistleblowers by creating criminal offences around their mistreatment and the establishment of a whistleblowing commission. And the other bill looks at establishing an office of the whistleblower to act as a point of contact, to maintain a panel of law firms, and to maintain a fund to support whistleblowers. And the second reading of both bills is awaited. I'll hand you back to Amanda now for the final item.
Thanks, Tom. Okay, so the final point we're going to talk about today is a very important change in relation to settlement agreements. And remember, as Tom mentioned earlier, these changes also apply in respect of employment contracts. So the government has committed to introduce new laws as soon as possible to restrict the use of non-disclosure agreements, or NDAs, in employment contracts and settlement agreements. And those new rules mean that NDAs must not prevent someone from making a disclosure to the police, regulated health and care professionals, or legal professionals. And in practice, that means you'll need to expressly carve it out from your NDA. Furthermore, if the SRA warning notice applies to you, and I'll come on to talk about that in a bit more depth in just a minute, just note that the carve-outs are much more extensive, and that's already in place. Just returning to the legislation, some other points that it raises are that NDAs must be drafted clearly, specifically, and in plain English. Although there is no prescribed wording here, there is already guidance published by the EHRC on what constitutes good practice. As far as settlement agreements are concerned, the new rules will require individuals to have received independent legal advice specifically on the terms of the NDA. And I think that this will potentially necessitate changes to settlement agreements templates, just to spell out that this has been done. So, for example, in the warranties given by the employee as to the advice that they've received, and also possibly in the advisor's certificate confirming the advice given. And it may also mean that individuals request a higher contribution to their legal fees to reflect this additional layer of advice that they need. Now, if the NDA is non-compliant, there will be adverse consequences for the employer. So for settlement agreements, a non-compliant NDA would be deemed to be void. And so that means you can't rely on it. So, for example, any clawback provision triggered by a breach of the agreement won't bite, nor would you be able to sue for breach of contract if the NDA was breached. As far as employment contracts are concerned, a non-compliant clause would not have the consequence of voiding the NDA, but it could give rise to a standalone claim for compensation. So your action point here is that you will need to review and amend your template documents in due course once those new rules come in, and we are waiting for them sort of imminently, I'd say. Now, just a very final quick word on the SRA warning notice. Obviously, it doesn't apply to all of you, but I think it is relevant to quite a sizable portion of our audience today. So the warning notice was published back in 2018, as Tom mentioned, but I mention it because it was strengthened significantly on the 12th of November 2020. And it concerns the use of NDAs by those that it regulates. So that's private practice lawyers, in-house lawyers, and those who work for law firms, including members of HR. So if you fall into that bracket and you haven't looked at it yet, then I would say that reviewing it should be a high priority action point. So the notice actually covers the use of NDAs in any form of agreement. It's not just confined to contracts and settlement agreements. It could potentially extend to commercial agreements, but sort of naturally it's more pertinent to the employment context. So first of all, as I mentioned a moment ago, there is a much more extensive list of carve-outs required that's set out in the notice. Secondly, if you use NDAs improperly, then you are at risk of disciplinary action, and the notice spells out what improper action or behaviour is in this context. Thirdly, if your client's instructions are to act in a way that's inconsistent with the notice, then it's said that you will need to consider whether you can continue to act for them. In other words, you can't absolve yourself of disciplinary risk by just saying, well, I was just simply implementing my client's instructions. And so for the non-lawyers amongst us, if you were to ask your own lawyer to include a very onerous NDA in a settlement agreement, then this would be the reason that they would push back on that. So if you are regulated by the SRA, do have a look at the notice as soon as you can and make sure that your template settlement agreements and employment contracts and potentially other documents are updated. Okay, and I think that brings us to the end of our main content. After the webinar today, we will be sending you a number of bits of useful information. So we will send you a recording of this webinar, and do feel free to share it with your colleagues. We will send you the copy of the slides that we've used today. And as I mentioned earlier, BDBF's 2021 Roadmap for HR, which captures all of the action points that we talked about and gives them a RAG rating. We'll also send you links to some of the other useful materials that we mentioned, and we will include a very short feedback request, and would be really grateful to hear your views, as it does help shape how we do these things in future. And finally, we'll also invite you to join our newsletter mailing list, which is a great way to keep track of developments in HR. For example, all the things we've talked about today, and you'll also get on the list for future events such as this. So I think that brings us to an end. I don't think we have any time to deal with any questions as we're at 1 o'clock now. If you've left a question for us in the chat box and you can't stay on for our bonus Q&A, please don't worry. Either Tom or myself will come back to you by email afterwards. Alternatively, if you are able to stay on for the bonus Q&A, we will pick up those questions when we start that session. Okay, so it remains to say thank you very much for giving up your lunch hour today to join us. We hope that you found it useful. If you'd like to stay on for the additional Q&A session, please stay in the meeting and we will get that started in just a moment. If you are unable to stay, then please do go ahead and sign out of the meeting when you are ready. We'll just give people a couple of minutes to do that.